Ladies and gentlemen, welcome at this web lecture in which we will discuss the most important terminology used in constitutional law. In constitutional law, we define the most important features of a country, of a state and of a government. That means that in a constitution we mostly find what kind of a state we have. Well, in constitutional legal terminology we often make a distinction between two types of states. On the one hand we have a federation, on the other hand we have a unitary state. And this says something about the level on which a state is governed. In a unitary state we see that a state is centrally led by one government that deals with all the most important things a state should deal with. There is no federated area or something like that that has equal powers. There's just one central government that is the highest authority in the country, and that's it. In a federation, it's slightly different. We do have a federal government, but they are not necessarily the highest authority. They share part of their authority with the federated governments. An example of a federation is the Russian Federation. In Russia, there is a federal government, but the federal government is not necessarily the highest government in authority or in hierarchy. Next to the federal government, there are federated areas with their own government. They are equal to the federal government, but competent in different areas. So, for example, the federal government is competent to deal with matters of geopolitical affairs, or the army, or the economy in general. Where the federated areas have their own government and they deal with the more local affairs, such as the schooling system or social welfare regulations, these kind of things. However, the federal government is not higher or lower than the governments of the federated areas. In contrast, we have a unitary state. And an example of that is the Netherlands. The Netherlands is centrally led with one highest government. They have only one highest authority in their country. Of course, there are provinces with their own regional government, and there are communities and so on. However, they are of a lower legal order. So the highest authority comes from the centrally led government. They deal with virtually all things a government should deal with. There is no distinction here. So this about a state structure, which is a different discussion compared to the government system. In the context of a government system, we ask ourselves the question how power is distributed. And traditionally we make a distinction between a monarchy and a republic. In case of a monarchy, power is vested in one person or maybe one institution, and that's about it. That could be a king or an emperor, for instance, or maybe even a dictator. In case of a republic, power is vested in a bunch of political institutions, could be a parliament, could be a combination of different chambers and so on, and it is headed by a president. So typically in a republic we have a constitution in which all these things are regulated, and the power is distributed through the political institutions I just discussed. An example of a monarchy is Great Britain, because Great Britain officially is headed by a queen, Queen Elizabeth. An example of a republic is Germany. In Germany there is no such thing as a king or a queen, but they have a chancellor who is elected by its people. Now, this touches upon a second discussion. Is a monarchy less democratic compared to a republic? Well, the original intention obviously was yes, a republic was there to become more democratic. However, in practice, labeling a country as a monarchy or a republic does not necessarily say something about the level of democracy a country has. To give you an example, Belgium is a monarchy but is considered to be very democratic, where the People's Republic of North Korea, a republic, is labeled a republic, but in practice we consider this to be a dictatorship, an extreme version of a monarchy, if you like. So the level of democracy cannot be deduced from the government system we have in a particular country. It's a distinct discussion. Now, this leads us to one last issue, the famous Trias politica. This was invented by people like Montesquieu or Mr. Rousseau. The idea is that there should be a division of powers. Powers in the hands of only one institution or one man or woman is dangerous because then we can abuse our power. But when there is a division of power at some point, it is less likely that we make abuse of our powers. So, in general, it is assumed that a healthy democracy has a legislature, creating the law, the administration, executing the law, and a judiciary, applying the law and give a final interpretation as what should be the correct understanding of the law. Those three, hand in hand, should rule a country in the view of philosophers like Montesquieu and Rousseau. A fun fact is that in China there is not a Trias politica, but they have a fourth branch, which is officially the army, which is unlike most other states who have only 3 branches of law. Well, these all are the most important phrases we use, the most important terminology we actually use in the context of constitutional law. Thank you very much for watching and good luck studying.